Morning, everyone. Okay. Thumbs up. And- Well, welcome, all of you back here to the flagship course, we were trial judges, general jurisdiction, and to all NJC alumni and friends joining us online. Welcome to the 147th Justice Jackson Lecture at the National Judicial College. I'm Dennis Aldana, President and CEO of the college. Special thank you to Thomson Reuters for your continued support of this program. I usually spend several minutes in this introduction reflecting on the life and legacy of Supreme Court Justice Robert Jackson, for whom this lecture series is named. It's quite a story. You can read more about him on the back of your program. Among his many notable achievements, Justice Jackson served as chief prosecutor at the Nuremberg War Crimes Trial and penned a powerful dissent for Motley versus the United States. That was the case in which the Supreme Court upheld the federal government's decision to incarcerate Japanese American men, women, and children during World War II based solely on their ancestry. The majority accepted the government's argument that wartime security justified curtailing civil liberties. Justice Jackson strongly disagreed. It's vital that we remember the lessons of such moments in our history, but we are also living through a period of profound consequence right now, one that I believe Justice Jackson would view with deep concern. Looking back over nearly 60 years of this lecture series, I cannot recall a time when the judiciary has been more frequently in the headlines or faced a greater test to its foundations. As judges, we understand that the judiciary does not enforce its ruling by force. Don't command armies. We rely in practice and principle on voluntary compliance. And when enforcement is needed, we rely on the cooperation of our constitutionally co-equal branch, the executive. But what happens when the executive branch is the subject of a court order and chooses not to comply? What happens if a party, unhappy with a judicial decision, simply refuses to follow it? These are no longer just theoretical questions. I'm sure you're following the ongoing litigation, executive orders, and the judicial ruling that responds. If the president or any executive official were to ignore a lawful or court order, that would present a serious constitutional crisis. Even more troubling, if this mindset spreads, if litigants begin to think, if those at the highest levels of government don't have to follow a court ruling, why should I? Then the integrity of our justice system could begin to unravel. I wish I could assure you that the foundational principle of our legal system, judicial independence, the rule of law, and equal justice under law are unshakable. But they will endure no matter the political winds or public pressure. I can't say that, Mr. There are times that the bedrock of our system may be at risk of erosion, but there is also reason for hope. Benjamin Franklin famously said, "Nothing in life is certain except death and taxes." I will add this: as long as I'm president of this college and with the strong support of our board of trustees, we will continue to prepare judges to uphold their oath of office, the same oath that you all have taken to decide cases fairly and impartially, based solely on the facts and the law. We also teach, as the model code of judicial conduct makes clear, that judges have responsibility to defend the independence of the judiciary. Some of our colleagues are facing threat and call for impeachment simply for issuing decisions grounded in law and precedent. Please keep these judges in your thoughts. If you get a chance, I encourage you to extend your support. You have such an opportunity right now because we are about to hear from a judge who served in one of the most significant courts in the nation. Judge J. Michelle Child serves on the U.S. Court of Appeal for the D.C. Circuit, widely considered the second highest court in the country due to its pivotal role in shaping federal law. She was a finalist for the Supreme Court seat vacated by Justice Stephen Breyer, and I was proud to support her, not only because she's a dear friend and alumna of this college, but because she embodies the very best of what it means to serve the law with integrity. Born in Detroit and raised in South Carolina by a single mother, Judge Childs was the valedictorian of Urban High School and earned a scholarship to the University of South Florida, where she graduated as the university's most outstanding student in 1988. She went on to earn both a JD and MBA from the University of South Carolina and became the first Black female partner of one of the state's largest law firms. A senior colleague recalls asking her to revise a legal memorandum, only to find a complete polished rewrite on her desk early the next morning. That's when I realized no one was going to outwork Michelle Childs, the colleague said. Everyone wanted to work with her, not because she was a woman or a Black lawyer, but because she was simply an excellent lawyer who delivered. That drive and dedication have defined her service in both state and federal courts. She has earned respect across the political spectrum, from Congressman James Clyburn to Senator Lindsey Graham. While under the district court bench, she told Law 360 that when she writes opinions, she isn't writing just for the litigants, but for the broader public. In many ways, she said, I've looked at my job as trying to bring some truth to that little joke. I'm from the government, I'm here to help. Judge Childs now serves as the president of the Federal Judges Association, representing mostly life-tenured federal judges. Just last month, the association issued a rare public statement condemning calls for impeachment or violence against judges who issue rulings that some find unpopular. In a message to her colleagues, Judge Childs wrote, continued violence, intimidation, and defiance directed at judges simply because they're fulfilling their sworn judicial duties only serves to undermine our republic, jeopardize the inheritance from our founding generation, and risk the collapse of the rule of law. At this college, we offer a course titled When Justice Fails, which examines how legal systems can break down, as happened in Nazi Germany and the Jim Crow era American South. And I hope we never return to such periods, but we must remain vigilant. I take heart knowing that we have skilled, dedicated, principled judges like Judge Childs, and like so many of you here today, who are prepared to meet this moment. We may not be able to outwork Judge Childs, but we can strive to match her commitment to justice. As someone who has known Judge Childs for a long time, I can tell you that she has always stayed true to being Michelle. Kind, brilliant, grounded, and always working to make things better for those around her. And yes, she got the Riz. You know what that word is? Just look at her investiture ceremony where everyone from back home in South Carolina turned out to celebrate her, right alongside many of the biggest names in Washington, including Justice Ketanji Brown Jackson and Brett Kavanaugh. That kind of turnout says something about who she is: respected, beloved, and admired across the board. And before we bring her to the stage, let me share a few lighter notes, a few did you know fun facts about Judge Childs. Because behind the bench is a person full of personality, passion, and joy. Did you know that when she was a deputy director for the South Carolina Department of Labor, her area of oversight included elevators and amusement park rides? So from time to time, she went out with inspectors to ride an elevator shaft or a roller coaster. She has won a few city championships for doubles tennis matches. She's a diehard fan of the University of South Carolina Lady Gamecocks. She plans her schedule around their biggest games, and yes, she'll be heading to the Final Four later this week to cheer them on in person. Once I tried to reach her, she casually mentioned she was in Paris. Naturally, I asked, "What are you doing in Paris?" Her answer, "Watching the Lady Gamecocks." Now that is kind of. Judge Childs is a dedicated traveler, making the most of every destination, fitting in museums, sampling local cuisine, and always learning along the way. She's a longtime music lover, particularly 80s and R&B. Colleagues say they caught her humming Chaka Khan's "Ain't Nobody" session. And as someone who shared many a dance floor with her since our early days as young lawyers, I can confirm she's got the moves. She's not above a little reality TV indulgence. She admits she's a Netflix binge watcher, because even federal appellate judges deserve a little guilty pleasure now and then. So now that you know a little bit more about the remarkable and very real women behind the robe, please join me in giving a warm National Judicial College welcome to the Honorable J. Michelle Brown.
Is it just you?
All right, good morning. I want to begin by expressing my gratitude to Judge Bennis Aldana. Wow, what an introduction. I have a few secrets about him too, but I was fair. Quite embarrassing. We're so proud of you as president of the National Judicial College. I grew up with Bennis as a young lawyer with the American Bar Association, and I challenge all of you to join on various affinity organizations as well. We mentored each other, we grew up in the law, and it's been so wonderful, I'll say how many years later, but that we've been able to join with each other and constantly support each other's career along the way. Thank you all for the National Judicial College, Krista Needs as well, Joy Langer, for their wonderful hospitality and letting me meet some of the local community, some of your donors, philanthropists, just various people who are supporting the college as they rightfully should. And I'm so proud of the work that has been done. I was one of you all over 15 years ago when I was a state trial judge coming through here on this general jurisdiction program. And since then, just the topics that you all touch upon, it's not just substantively, but things that matter to all of our communities in terms of the diversity, the cutting edge topics, and those things that really meet the citizenry of our various communities. So thank you, it's so wonderful to be here. And congratulations to all of you all as new judges. This is your opportunity to just feel so rewarded that you get to administer justice fairly and impartially. Take the time to enjoy the journey. As each case comes in front of you, think about it. Take the time to take a moment off the bench and think about it, because you don't have to make a decision. You are in charge. That decision doesn't have to come immediately. If you need more time, if you need to call a colleague, and you all will become fast friends with each other across state lines, far, near, abroad, take the time, because what you are about to do, have done, and embark upon is so important. Every single litigant in front of you, it matters. It matters to them. You will do some of the most high-stakes litigation ever in your areas, ever in the nation. I could not believe that just even on the DC circuit, I was telling somebody, it's like a court of history. Last year, I ruled on Holocaust survivors. Think about for 12 years or more that their cases have been going up and down about their artifacts. International arbitration in Africa, dealing with some of the run-over cases with Guantanamo Bay, torture, terror, presidential immunity, things that deal with our legislative and executive branches. So some of these things that are truly historic are some of the things that you all will deal with well as your class actions, your multi-district litigation. Just imagine all of that you get to touch upon. So enjoy the journey, because you will have the opportunity to make some of the most consequential decisions as you come along. Now, because of the National Judicial College's commitment to the rule of law, it's an immense honor to give this lecture honoring this respected jurist, Justice Robert H. Jackson, who served our Supreme Court as an Associate Justice from 1941 until his death in 1954. And over the remarkable career, he was a Supreme Court Justice, Solicitor General, and Attorney General. And Justice Jackson demonstrated an unwavering belief in the rule of law. And unlike many of his colleagues, Justice Jackson did not receive a college degree, and he did not complete a traditional law degree. His journey was from very humble beginnings and one of the most respected legal minds in American history, speaking to his commitment to the principles that he defended. And it further shows that the values of justice and the rule of law are deeply ingrained in the fabric of our country. Now, preserving the rule of law was a theme in Justice Jackson's speeches and writings. In an address at the laying of the cornerstone of a new American Bar Center, a testimony to our faith in the rule of law, Justice Jackson emphasized the importance of the rule of law as a bulwark against power. Jackson stated, "It is the nature of power always to resist and evade restraints by law, just as it is essential nature of law as we know it, always to curb law." In particular, he stressed the importance of an independent judiciary as a restraint on arbitrary power. We believe in a strong and independent judiciary charged with adjusting and applying law to conditions of our time. By independence of the judge, we mean more than freedom from subservience to other branches of government. We mean the largest freedom humanly attainable from his own partisanship, class interest, political bias, or group pressures. We maintain our right respectfully to criticize what we may think errors of honest judgment by our courts and judges, but we can show no leniency toward judicial partisanship, faithlessness, carelessness, or irresponsibility. Again, in his address to a testimony to our faith in the rule of law. And I could not think of a more fitting way to honor Justice Jackson's legacy than by reflecting on the rule of law and the role of the courts in preserving our rule of law. So today I suggest to you, the Republic is safe as long as the courts remain open. Now, our democratic institutions are going to remain safe as long as our courts are preserved. By keeping our courts open, I mean more than just the physical space of these particular buildings. I mean ensuring that people can trust that they can turn to the courts as a safeguard against abuses of power and a means for preserving their rights. During the Civil War, the Supreme Court refused to allow the courts to be closed because of the ongoing emergency, saying, "The Constitution of the United States is a law for rulers and people, equally in war and in peace, and covers with the shield of its protection all classes of men at all times and under all circumstances." Independent courthouses embody the very foundation of justice in a democratic society. Justice thrives in the light and withers in darkness. Consider for a moment what it would mean if the courts were closed. That doesn't mean that the doors are merely locked, but it silences the voices seeking the redress. As I just told you how important your role is, hearing those voices and determining what their redress is. It also deals with the immunity of power from those who should be held accountable and the erosion of our social contract that binds us together as a society. Open courts stand as the practical manifestation of our collective commitment that no one, regardless of wealth, status, or influence, stands above the law. So today I invite you to reflect with me on how accessible courts serves as both guardians and embodiments of the rule of law, examining certain historical moments that preserved our liberty in the face of tremendous pressure. Our task ahead is to re-examine the importance of judicial independence. Let's start at the founding. Few values were as important as the founders as the separation of powers. And they designed an independent judiciary, again, as the indispensable bulwark against tyranny and to ensure the judiciary is able to enforce the law with fairness, equity, and impartiality. Even in the darkest times in our country and history, Americans have turned to the courts to protect their rights. To keep the courts open, we have to remind ourselves that that fair and independent courts are necessary for a functioning democracy. That is all of our challenge. And then I'll conclude by reflecting on the path ahead. We have to maintain our judicial independence by requiring the cooperation of the entire legal profession and the other branches of government. But ultimately, we as judges have a role to play in preserving that judicial independence. We have to show upright, ethical behavior. And I know you just had your course in ethics, but we also have to be reminded by the public and to remind the public that independent courts are that indispensable to our democracy. So let's reaffirm and rebuild our shared commitment that not only among judges, but among the citizenry as a whole for judicial independence. Now, securing judicial independence is more than just about protecting ourselves. It's about preserving the rule of law for everyone. So let's make sure that everyone understands that this is the benefit for our entire country. Justice Felix Frankfurter said, "There can be no free society without law administered through an independent judiciary. If one man can be allowed to determine for himself what is law, every man can. That means first chaos, then tyranny." Indeed, as the Federal Justice Association, as he mentioned, recently emphasized, ensuring judicial security is not just about protecting individuals, it's about preserving our entire legal system and the public's trust in that system. So how do we do that? How are we going to keep the republic safe from tyranny? Well, let us be reminded that for the founders, again, separation of powers. And history offers us some of these most powerful lessons. Think about Britain, the experience with despotic rule under King Charles I of England, otherwise known as the 11 years of tyranny in 1627 to 1640, and the personal rule. King Charles ruled England without calling upon Parliament and suppressed judicial review by suspending the regular operation of the courts. Judges who resisted were dismissed. And what followed was a collapse in the public trust of the courts and a tension toward a path that led to English Civil War of 1642 between supporters of King Charles and those of Parliament. What was clear is that when the courts were closed, unchecked power rose and social stability fractures. And then for the framers, protection from arbitrary removal is necessary to ensure the judiciary's independence. Oh. There we go. So, in Federalist number 78, Alexander Hamilton declared that if then the courts of justice are to be considered as bulwarks of a limited constitution against legislative encroachments, this consideration will afford a strong argument for the permanent tenure of judicial offices, since nothing will contribute so much as this to that independent spirit in the judges, which must be essential to the faithful performance of so arduous a duty. In other words, we cannot act with fear or favor or political expediency or for our friends or for our political enemies and be concerned about that whenever we are making any rulings on the bench. And those are some of the things that we have to always have as our consideration. And to be clear, the founders did not believe that judges should be immune from accountability. That is not at all what I'm stating. Rather, they believe the judiciary should be subject to a standard of good behavior for continuance in office. And the Constitution adopted this structure in Article 3's provision that judges shall hold their offices during good behavior. They were also influenced by Britain's experience with the Star Chamber. That's a court that was recognized by British kings to try political rivals without procedural safeguards. Like the Inquisition, the Star Chamber placed a premium on getting defendants to admit their guilt and confess. Witnesses were examined privately, and defendants were not given an opportunity to cross-examine. The legacy of the Star Chamber pushed the framers to enshrine public guarantees to due process in our Constitution, including the right against self-incrimination. The framers understood that without due process, individuals could not trust the courts to act fairly and impartially and to protect them against arbitrary rule. The judicial independence goes hand in hand with due process to ensure that courts are open to the public and they will truly protect people from despotism. Now, the decision to give federal judges lifetime tenure was not a mere formality. It was a deliberate choice, informed by history to ensure that judges could make decisions based on legal reasoning rather than political expediency. And then the judges are guardians of liberty. At best, the judiciary has struck down unconstitutional laws when it's at its best, defended the powerless against the powerful, and ensured the equal application of justice. Even in our darkest times in our American history, including those decisions that were against or for marginalized and the disenfranchised, they have turned to the courts to vindicate their rights. Think about it. Before the Civil War, even as free Black Americans were disenfranchised in several states in the North, they sought to claim their rights through the courts. The experience was not easy, and most of the time it was very unsuccessful. But for most Americans today, going to court means going to family court, small claims court, probate court, just any type of general civil litigation. But these cases sound in private law, fundamentally about protecting rights. And as many historians have shown in these daily interactions, it's that time that Americans are informed that their belief in the courts is how they vindicate their rights. And one of the most prominent and potent examples of the judiciary role in defending the Constitution were the values that were enshrined in the case of Brown v. Board of Education. Beyond the Supreme Court, other lower courts also had a significant role in implementing Brown. Even at the DC Circuit in Adams versus Richardson, DC Circuit enforced school desegregation by holding federal agencies accountable for ensuring compliance with civil rights laws and federally funded education programs. And protecting rights is not easy. Think about cases like Dred Scott, Plessy versus Ferguson, Korematsu. They stand as a stark reminder of our duty as judges to ensure that courts defend the Constitution. In those cases, again, Americans turn to the courts to vindicate their rights. Courts sometimes fail to stand up for justice. Sometimes we fail, we're flawed, but that's what we have appellate decisions for. And as Chief Justice Roberts would later say, Korematsu was gravely wrong the day it was decided, and it has been overruled by the court of history and has no place in law under the Constitution. And sometimes those cases are morally wrong. Sometimes that righteous choice requires bravery, standing up against prevailing political winds on the side of justice. So you'll have to be brave. I am not considering or suggesting activism in judging. Don't take that as wrong, but just as someone who has to stand up for what they believe the law is and what those choices should be. Don't shrink to believe that you don't have that power. And for example, in 1957, President Eisenhower had to deploy a contingent of the 101st Airborne Division to Little Rock, Arkansas to protect the Little Rock Nine. 9 Black high school students seeking to attend the city's integrated high school. Aside from public disagreement with the outcome of the case, Brown and subsequent desegregation decisions also triggered backlash against the judges themselves. Even at the height of the success in defending the Constitution, judges began to encounter threats to their independence. So what are some of our challenges to judicial independence? In the aftermath of civil rights revolutions generally, courts worked to enforce desegregation, but judges were confronted by different forms of backlash, calls for impeachment, threats for violence, having many forms of that retaliatory conduct for just doing their job. And physical threats to a judge were the most extreme response. Unfortunately, there are so many historical examples, and here we are. These are all 2025 headlines. Threats to federal judges increasing, U.S. Marshal Service, judges fearing for their safety. As president of Federal Judges Association, I'm getting lots of emails, lots of calls, death threats, people who are blowing up children on social media, dealing with their wives and things of that nature, you know, just people who are innocent spouses that have signed up with you all with respect to what you all are doing in terms of the bravery of yours. And consider Judge Frank Johnson of Alabama. In response to Governor George Wallace's intransience in leading Macon County Board of Education, Judge Johnson issued an unprecedented statewide order to enforce desegregation across all of Alabama's schools. Crosses were burned in his yard. His mother's house was firebombed. Judge Julius Waring of South Carolina similarly faced cross burnings and gunfire for his rulings advancing certain justice as well. And in July 2020, a disgruntled lawyer targeted the home of Judge Esther Salas, who's on our federal bench. She's the U.S. District Court for the District of New Jersey, killed her 20-year-old son right in the foyer of her home, shot her husband, who had over 15 surgeries and luckily is alive. And she is out there speaking diligently and fiercely about the rule of law and how words matter. And I'm going to give you all some examples through our canons in a little bit about even in your ethical responsibilities, how you can still stand up for the fair and impartial administration of justice. Following attacks on his home, Judge Johnson remarked, "There were many times that I felt alone. I don't care who you are. When something happens and the entire state rises up through its politicians and its press, you become apprehensive for your family, sometimes waiting for something to happen. And yet we judges understand that making tough decisions is just part of our job. As judges, our concern is also with preserving the rule of law and the institutions that protect the law. So these threats are on the horizon. Fellow judges, my dear colleagues, I realize it's not easy time right now to be a judge. I showed you those headlines, and again, those are 2025. But I talked to you about history, and here we are again, over time, seeing a lot of these threats again. Recently, the director of the U.S. Marshals reported that in 2023, the Marshals investigated 457 threats against federal judges compared to 224 in 2021. And it's on the rise again now. I will give you an example recently as someone who has ruled against various things. I thought I was just home on a Saturday night. Domino's Pizza comes to my house. I don't order pizza to my house. I just have not. My daughter, she'll say, well, you didn't have any food at home, so I'm ordering DoorDash. And so she just happened to be at the beach. So I called her and I said, did you all get the order wrong? You didn't change the app? She said, I didn't order anything. I thought nothing of it. Sorry, that's not ours. So I'm on a federal judge call and I tell them about this incident, say, oh, things are just getting a little eerie. Still didn't think anything about it, just kind of having conversation. Well, later on, we get information saying that those who have ruled against certain things, we know where you live. Domino's Pizza has been coming to your homes. So just think about being brave, doing what you need to do, but being protective of your surroundings, letting your security know, marshals, your courtroom security officers, and everyone else, your colleagues, your friends, just all of that. Because I still want you to stand tall for the judiciary, because what we do matters for every individual, organization, corporation, institution within the case. And these calls for impeachment have been preceded by an extensive investigation of, not into charges of misconduct, but they're consistently following decisions, just mere decisions by judge. And of course, we have an appellate process for that. I welcome it. I want to be right, and I'm going to do everything I can to do so. And I'm never going to be upset with the lawyer who wants to appeal me. I'll try to do my best to be correct on the front end, but then there's that process. And so you should always direct somebody toward the appropriate process. And that is not to come to your home and kill your child. These public rebukes have become so common that Chief Justice Roberts recently offered a rare and forceful response, reminding us that for more than 2 centuries, it has been established that impeachment is not an appropriate response to disagreement concerning a judicial decision. The normal appellate review process exists for that reason. More generally, in his year-end report for 2024, Chief Justice Roberts warned against threats directed at judges, stating, there is, of course, no place for violence directed at judges for doing their job. And violence, intimidation, and defiance directed at judges because of their work undermines our republic and are wholly unacceptable. We should not have to worry about any of those types of threats as a fundamental threat, because there are separations of powers, and that undermines democratic governance. When judges face removal or unpopular rulings or any type of threats rather than actual misconduct, we undermine the judiciary's essential independence. Now, I've indicated his statement, and the rule of law ensures that no person is above the law and that anyone, regardless of their circumstances, can have a fair day in court. And again, that's where you all come in with respect to due process and making people feel heard. And as Justice Sotomayor highlighted more recently in a speech last week, judicial independence is critical to everyone's freedom because arbitrary power is just that. It means that everyone is going to be subject to unfairness at someone's whim. So I'm glad that regardless of how you've been appointed, elected, selected, that everyone is at least in agreement as to our role with respect to separation of powers and judicial independence. What happens when that judicial independence is then lost?
So kind of go forward, yeah.
When it's lost, we have to think about other countries. For example, South Africa, when they had undergone apartheid. They claimed to have abided by the rule of law, but in those circumstances, the courts operated only as an instrument for the enforcement of arbitrary and nefarious laws. In the aftermath of apartheid, South Africa's courts were so delegitimized that they had to be radically transformed through a constitutional reform before they could regain the public trust. And then we have the chilling experience with Nazi Germany. That's the collapse of an independent judiciary. In Nazi Germany, purges and removal of independent judges, as well as the appointment of political favorites, were early signs of the country's descent into dictatorship. The Nazi regime required that all judges swear an oath of allegiance to Hitler, not to the laws or to the German Constitution, thereby abandoning their role as impartial arbiters. And in those circumstances, court can degenerate into kangaroo tribunals. This regime did not just close the courts, they transformed into weapons of state ideology. Political enemies are dragged into court for sham trials with predetermined outcomes. And even when judicial independence is lost, some countries have managed to restore trust back in their courts, but it takes a lot of work. One great thing about being part of the Federal Judges Association is that we're part of the International Association of Judges, and I was just in South Africa in October. And the horror stories that we hear from some of the other countries in terms of judges being minimized, thrown in prison. I just got an email the other day from what's still going on in the situation with Afghanistan and judges trying to be sneaked out of the country. Judges who have been jailed, judges who've been demoted, people who, without their salaries, just all of those types of things. And so therefore, the rule of law is so important. And we are so lucky in America to hold on to it. So think about the independence that courts come under threat with. So our institutions have to stand strong. So how do we keep the court's doors open? First and foremost, we have to continue to feel our constitutional duty to protect due process and access to justice. I'm always going to start with what do we do, because we are in the independent third branch of government. And that requires also a commitment from the other branches of government. But ultimately, as Justice Robert Jackson would also remind us, it requires the judges being willing to make the tough decisions. In his dissent to Korematsu, Justice Jackson emphasized the importance of preserving the rule of law, even in the midst of perilous wartime circumstances. And making those tough decisions may at times require that we be willing to tell the president or Congress that they're even wrong. And that he emphasized that it's the duty of the judges to be the last to give up on the separation of powers and our own independence. And of course, we have to act fairly in a manner consistent with our canons of justice, of ethics. Canon 1, maintain and enforce high standards of conduct, personally observe those standards, have integrity and independence of the judiciary and how that's to be preserved. Canon 2, respect and comply with the law. Act at all times in a manner consistent with that confidence and integrity and impartiality of the judiciary. Then when you also get to Canon 4, and this is the part that I want you all to know because I get calls from around the country, but we can't do anything. We're judges. We're supposed to just sit here and take it. No, we're not. A judge may express opposition to the persecution of lawyers and judges anywhere in the world if you've ascertained after reasonable inquiry that the persecution is occasioned by a conflict between the professional responsibilities of a persecuted judge or lawyer and the policies and practice of the relevant government. And what we're saying there is that somebody just physically threatened just because they made a decision in court based on the facts and law, however they perceive that they should rule, that is inappropriate. And so rely on your canons to do that. So I see the time is up, but thank you for the time to just talk about this particular very relevant moment, focusing on Justice Jackson, seeing how long ago he was a Supreme Court justice, but how relevant all of this is. Thank you for the opportunity to be with you.
Judge Childs, because I work with time, does we have a burning question to ask this time? But if not, she's gonna stay and join us for lunch a little bit before she has to go to the airport, so feel free to directly ask questions or speak to her, comfortable. But we want to also present you Judge Child, the focus of our appreciation. It's our additional gift or exactly which is a person. Yeah. That will tell the signature t-shirt here in the college, which is more of our staff today, I think Tuesday. Because everyone deserves a good guy. So again, thank you for reminding us of history, our sacred responsibility and responsibility to defend ourselves as judges when we can, consistent with the our ethical responsibility. So thank you again. Appreciate it. Thank you all.